Hello, everyone. Good afternoon from the East Coast of the United States. Here we are on Monday, and a lot has happened not only this week, but even this weekend. And it again reminds us of how rapid world events are unfolding in this age and how important it is to maintain our relationships and Israel's alliance, both with the United States and with Europe, which is why we're here today. Just as a quick reminder, a week ago, Israel eliminated the number two in Hamas, or at least we think so, Mohammed Deif. On that same day, there was an attempt to assassinate a former president of the United States, who later that week became the official nominee during the Republican convention. After that, on Thursday, if I'm not mistaken, there was the Houthi unprecedented attack on Tel Aviv. With a drone that traveled over 2,000 kilometers. The United States shot down 4, but 1 reached the shores of Israel. Immediately after that, or at the same time, Netanyahu and his security advisors agreed to renew the negotiations for the hostage release and a possible ceasefire in Gaza. The ICJ followed with its decision on Friday, the advisory opinion that we'll hear more about today. The IDF responded on Saturday to the Houthi attack by traveling the same distance, 2,000 kilometers, to reach the port controlled by the Houthis. And then this weekend, of course, we heard that President Biden decided to bow out of the race, nominating Vice President Harris. And Bibi Netanyahu is on his way to Washington as we speak to meet with both Biden, Harris, Trump, and speak in Congress on Wednesday. This just gives you a sense of how rapid the events are. But here we are discussing long-range issues and deeper political and legal consequences of the ICJ advisory opinion on Friday and our deeper relationship with Europe. So without further ado, Joan Ryan, our very able director in London, will take the floor and introduce our speaker. Joan, the floor is yours.
Thank you, David, and hello to everybody on the call. I have the pleasure and the honour of introducing to you Jonathan Turner. Jonathan is the Chief Executive for UK Lawyers for Israel. He was admitted to the Bar of England and Wales in 1982 following degrees in law at Cambridge University and European law at the Université Libre de Bruxelles. In 2011, Jonathan and a few others started UK Lawyers for Israel as a voluntary association to counter BDS and other anti-Israel activity using the law. He has played a major role in many important projects, as well as overseeing its development from a small group of volunteers to one of the more significant organisations countering anti-Israel activity in the UK and around the world. I'm very proud to say that Jonathan is a patron of ELNET UK and has shown us tremendous support and guidance during the 3.5 years we've been up and running. Jonathan, can I turn to you to talk about this advisory opinion published on Friday, July 19th, 2024? The International Court of Justice concludes that Israel's ongoing presence in the occupied Palestinian territory, including East Jerusalem, violates the Palestinian right to self-determination and is illegal. The court calls for Israel to bring its presence in these territories to an end as rapidly as possible. All Israeli settlements in these territories must be evacuated. As CEO of UK Lawyers for Israel, can you talk us through the court's actual findings, their legal ramifications for Israel, and any legal impacts that could transpire following this? And we know this is an immediate and a long-term issue, and when hostilities cease, this legal battle, these legal rulings will still be there. Over to you, Jonathan. Thank you.
Well, thank you, Joan. Thank you very much for inviting me. And may I also say how delighted I am to be a patron of your excellent organisation, which in a short space of time has done so much to advance cooperation between Israel and the UK, particularly in your case, but also I was aware previously of its activities in other European countries, and it's certainly become a very important organisation for us all involved in seeking to improve Israel's relations with other countries and its standing in the world. Unfortunately, this opinion of the International Court of Justice, and I do stress that it is an advisory opinion that is not binding, and for that reason I prefer to avoid the use of the term findings, because it has no authority to actually make findings in a case such as this. It can merely express its legal opinion on the facts with which it was presented, which unfortunately were a most unsatisfactory set of facts or statements as to fact, many of which were wrong and were certainly thoroughly one-sided, as indeed some of the judges remarked, but rather oddly that didn't present them signing on to the opinion. They said that we're not going to make any findings as to any specific instances, but then they made a whole series of observations saying on the information available. Well, that may be very well, but the information available was unsatisfactory. And I'd also point out that there was a strong dissenting judgment by the Ugandan vice president of the court, Judge Julia Sebutindi, which I would urge people to read if they can, because it does deny many of the principal points that are made in the majority judgment. It should also be noted that there were a number of supplementary opinions and of different judges who agreed with the main judgment but dissented from some of the conclusions. Those included three of the European judges sitting on the court. And of course, it is a highly political body. But the majority did take the view on the information that they'd been provided with, that Israel's presence in the West Bank and the Gaza Strip must cease as soon as possible. They seemed rather oblivious to the practical consequences of that. And this was actually a point that ELNET and UKLFI made in a joint statement. We actually put in two joint statements to the court. Unfortunately, non-governmental organisations are not treated with any significant respect by the court. Their submissions don't go on the court file. But I do think that in this case, the dissenting Judge Sebutindi does appear to have paid some attention to what we said, and particularly in the supplementary submission, we pointed out that Israel's cessation of its presence in the Gaza Strip back in 2004 had disastrous consequences for peace and a satisfactory resolution of the situation. And if that were to be repeated in the West Bank, it would make the terrible loss of life and deprivation that has occurred for Gazan citizens of Gaza, as well as many citizens of Israel, of course, as well, it will make that seem a relatively small affair if Israel's presence in the West Bank is terminated without satisfactory security arrangements. The court has called for the presence throughout the West Bank, including East Jerusalem, to be terminated as soon as practicable. That includes East Jerusalem, and the security issue that would present in Jerusalem, for a start, would be quite extraordinary and quite impossible to deal with. It seems quite likely that a Palestinian regime in the West Bank, without the backing of Israel's security, without Israel being present in the West Bank, would very quickly be taken over or dismantled by Hamas or other terrorist entities, and the result would be quite appalling, and would make any prospects for progress even worse than they are already. So how did the court reach this conclusion? So the court starts from the view, which is of course widely shared, but not indisputable by any means, that certainly the West Bank, but they also said the Gaza Strip was occupied by Israel even between 2004 and October of last year. Now that is, as far as the Gaza Strip is concerned, that is very questionable, because when other countries' activities are considered, the courts, including the European Court of Human Rights and the International Court of Justice, have said that you only occupy a territory if you have control of the territory on the ground, with boots on the ground. And it took an army of and the mobilization of 350, 400,000 soldiers in Israel, but an army of about 100,000 to try and take control of the Gaza Strip. And it took weeks to achieve that. So how you could say that Israel was really in control on the ground in the Gaza Strip between 2014 and 2023 is quite extraordinary. They said it had some control over the borders, but even there it had quite evidently very little control over what went on in Rafah. How else did all those missiles and armaments and other war materials get into the Gaza Strip? I mean, it's bizarre to try to understand on what basis they could have reached that conclusion. As far as the West Bank is concerned, obviously Israel has had a greater degree of control. There are those who would say that nevertheless its status is somewhat special, and that, for example, under the doctrine of uti potestatis juris, which applies to everywhere else in the world where a mandate is ended, or a larger entity is disbanded, or a country becomes independent, some people would say, well, the West Bank is precisely in that situation, and it should not be regarded as territory to which Israel has no rights, and so on and so forth. So there are those points, but let's take the view for the moment that the West Bank was and is occupied by Israel. Hitherto, it's been generally taken to be the case that an occupation as such is not in itself unlawful, and in particular it remains lawful as long as the reasons for the occupation, which typically are the need to establish security and avoid a situation in which military security is undermined or made impossible, and those reasons still very much exist in relation to the West Bank. But what the court said was that the extent of Israel's control and its use of its position in the West Bank was such as to make its continued presence unlawful. Now, this was one of the points on which several of the judges dissented. They said it didn't make it unlawful. It just meant that some of the acts that Israel commits are unlawful. And indeed, it is, I would say, really rather difficult to justify that it makes the whole presence unlawful, even if you take the view that some of the acts done by Israel are unlawful. And of course, there are arguments about that, which the court ignored anyway. Essentially, the court said that Israel's presence in the West Bank amounted to annexation, but that's not the case. It has annexed the whole of Jerusalem, and there are very good grounds which actually pointed out in our statement supporting and justifying that annexation in terms of, amongst other things, Israel has a very strong claim to be entitled to the city of Jerusalem. And when one talks about self-determination, the court said that one of the reasons why Israel's presence in the West Bank is unlawful is because it impedes self-determination, but it ignored the fact that a survey of Israeli Arabs, which people tell me anecdotally is a fair and accurate one, a survey by a Palestinian news agency, the Shifa news agency, at the end of 2021, found that 93% of Jerusalem's Arabs would prefer a continuation of Israeli rule. Now, self-determination is about entitling people to determine how they are governed in the future. And if the Arabs of East Jerusalem want Israeli rule, and the Jewish community in Jerusalem, the two main ethnic communities in Jerusalem, large proportions want a continuation of Israeli rule and don't want a divided city, which would be an economic and security disaster. So it's a perfectly reasonable and understandable view. But if they don't want it, why is the court saying we're going to ignore your entitlement to self-determination and say we think we know what is best for you? It's a kind of almost colonial mindset. I'd also add to the figure in this, fair to say, unofficial opinion poll, but the official survey carried out by the Israeli Census Authority, as it does every year, asked a question last year of people throughout Israel, including the whole of Jerusalem, of which Israel has claimed and treats as its sovereign territory. It asked the question, are you satisfied with your life? And 86% of Jerusalem's Arabs said yes, they were satisfied with their life. Now, I can't help wondering, if you ask British people or French people or Parisians or Frankfurters, are you satisfied with your life? I would be surprised if you found as high a percentage as that. It is fair to say that the Jewish inhabitants of Jerusalem were even more satisfied. They were 91% satisfied, but overall, a high proportion of Jerusalem residents, including Jerusalem's Arab residents, were satisfied, which goes to support the finding in the survey that I mentioned regarding how would you like the city of Jerusalem to be governed? Would you prefer Israeli rule or Palestinian rule? I mean, I think I've tried to summarize some of the main points of the judgment, and obviously I'm happy to flesh these out more in questions and the consequences of it.
Thank you, Jonathan. Yes, that's really pulled it together nicely, very informative, because it's quite complex in terms of the presentation that was made by the court itself. It was quite a lengthy reading of their what did you call it? A finding, as opposed to a ruling or what? Can I ask you, so what in your view constituted the key pillars of Israel's defense, and why do you think these points were not shared or endorsed by the ICJ's panel of judges? I mean, many feel that that the ICJ has unquestionably adopted the historical and legal narrative of what we might call the Palestinian side.
Well, there was no defense by Israel. Israel took the view that the court shouldn't be considering this issue because it's about what is a bilateral dispute between Israel and the Palestinians. And moreover, under the Oslo Accords, Israel and the Palestinians have agreed to seek a negotiated solution and not to do anything that would change the status of the West Bank or the Gaza Strip in the meanwhile. So Israel put in a statement saying we oppose the court hearing it for these reasons, but didn't put any substantive defense forward. And regrettably, really, no other states did. One or two states did refer to the possibility that certain points might be disputed, but there was no real substantive defense put before the court, and this was, of course, unfortunate. Well, one of the points I would speculate about is whether this will lead to a change in Israel's legal strategy in relation to international tribunals. But I'll come to that, if I may, in a moment. I just mention that a number of countries did support Israel's contention that the court shouldn't be considering the case at all. When I say a number, I'm a handful in terms of the number of states in the world. May have been half a dozen or so countries said that. Very few seem to really pull their weight. One I would highlight for doing an excellent submission was Fiji, which really did put in a very good submission. But this was very few and far between. So there wasn't really Israel's case in front of the court, and that's of course part of the problem. But Israel didn't want to give any credibility to this. I think it would have been better if Israel had certainly having taken the view that it wasn't going to appear itself. I think it could have done more to encourage other. It did try to encourage states to intervene, I imagine, but very few were willing to do so, to take the heat on behalf of another country. But it could have encouraged NGOs to do more, and more, I think, could have been done. As I say, the court doesn't pay much attention, but I think if the UKFI and ELNET, we did our bit, I think. I would have liked to have had more publicity for our work. And I think if there had been more encouragement of that, I think it would have, it might have had the effect of ensuring that the case was more considered by the International Court of Justice. But we do have to face the fact that this is a very politicized and vast tribunal presided over by a Lebanese judge who, as Lebanese ambassador to the United Nations, condemned Israel on hundreds of occasions. UN Watch, I think, counted 212 times or something like that, and made vituperative remarks about Israel, and was even put forward to be the Lebanese prime minister with the backing of Hezbollah, admittedly as a compromise suggestion when no one else could be elected under the Lebanese practice and procedures. But Hezbollah was willing to say, well, okay, let's have Nawaf Salam as Prime Minister. Will agree to that, showing that he has Hezbollah's approval. Now, Hezbollah is a genocidal terrorist organization engaged in open warfare at the moment with Israel. And to have a judge who commands the confidence of Hezbollah ruling on an important, not ruling, expressing his opinion and organizing the court in expressing its opinion on Israel at the present time is, I'm tempted to say obscene, but that's perhaps a bit
and prescribed by many countries. A prescribed organisation named as a terror organisation.
Yes, including the UK, and also I think I'm just trying to remember, is it designated by the EU as well, or not? I can't remember now, but
certainly by the US.
Yes.
Could I just pick up one point that hasn't been referred to very much? I know, as you said, the court called for Israel to rapidly quit the occupied territories and ruled Palestinians were due reparations for the harm of 57 years of an occupation that systematically discriminates against them. This seems to, whether you accept that or not, it completely ignores the fact that Israel offered a state in, I think, 2000 and 2008. And this judgment seems to completely ignore any of these kind of facts on the ground in relation to the relationship between Israel and the Palestinian territories and the involvement of all others, not least those who've been trying to support the negotiation of a peace deal and a two-state solution over many years.
Well, yes, there's a general principle of law that even a person who is wronged should mitigate his damage and cannot claim to the extent that he could reasonably have mitigated his damage. But over and above this, what the court seems totally unaware of is the extent to which Israel's presence in the West Bank and the Gaza Strip enormously improved the lives of Palestinian Arabs, particularly in the period when Israel was actually in full governmental control of those territories. There's an essay by Professor Ephraim Karsh, which goes through the statistics, and there was a monumental increase in living standards. The conditions in the territories were absolutely dire in 1967 when Israel came into control of them. There was no electricity throughout most of the West Bank, no mains electricity. There was no a mains supply of water in most places in the West Bank. Disease, the mortality rate of infants was extremely high. The standard of living rose faster than in what were in that period well-known economic miracles like Singapore and so on. The actual increase in GDP per capita of the West Bank and Gaza Strip were even higher, even though the population was expanding at a very rapid rate as a result of the efforts made to establish by Israel to ensure a clean water supply and to ensure facilities for hygiene and putting in sewage installations in the towns and so forth. So there was an enormous improvement in the medical and sanitary conditions, which of course came through as a great increase in the population. But even despite that great increase in the population, the actual living standard, the GDP per capita, increased enormously in that period. And in fairness to the Palestinian Authority, although its governance has been unsatisfactory and corrupt and incompetent in many cases, nevertheless, the GDP per capita has risen, particularly in the West Bank, quite a lot, even since 1995, when the Palestinian Authority governance of most of the West Bank, most of the population in the West Bank, was transferred to the Palestinian Authority, and likewise in Gaza in 1994. So again, Gaza Strip had seen until really the advent of Hamas control, Gaza City had also achieved a considerable rise in the standard of living under Palestinian Authority administration. So this suggestion that somehow damages are payable is quite it's based on a complete misunderstanding of the position. And there's also, and I don't know whether they're saying that the damages should be such as to would bring the Palestinians up to the standard of living of the Israelis, or whether it's saying they should be brought up to the standard of living that they would have had if not for the presence. But if they're latter, then it's zero, because they've benefited from the Israeli presence, not being disadvantaged, except perhaps you might say from a political point of view, they haven't had full representation, but certainly from a material point of view, they benefited from the Israeli presence. But if they're saying, well, they should be brought up to the same standard of living as Israelis, well, that's I don't see any legal basis in terms of general principles of law that at all.
Can I remind people that if you wish to put a question to Jonathan, please put it in the chat. You're very welcome. We like to see your questions. We want to encourage you to engage. I have got one question. I'll take this at the moment, and then I'll come back. I think it's Seth Weinstein. Seth, are you there? Would you like to put your question to Jonathan?
Yes, I would. What troubles me greatly is the hypocrisy in these international organizations between the way Russia is being treated in Ukraine. Don't forget that they actually have annexed Crimea and eastern Ukraine and invaded brutally the rest of Ukraine and are targeting civilians intentionally. How do you explain this lack of UN or ICC or any international body being willing to tell the truth about what Russia is doing? And why is Israel considered such a target for this type of behavior?
Well, in fact, Russia was ordered to remove its troops straight away from Ukraine. In fact, in a completely unqualified order of the International Court. So it wouldn't necessarily be true. The merits, I would say, are completely different, because Russia just invaded Ukraine with no real justification whatsoever, and with some kind of bogus claim that Russian ethnic people in Ukraine were victims of genocide, which really had no basis whatsoever. And the International Court of Justice found against Russia. But or when I say found, it made an order against Russia. The case is ongoing. I'll be surprised if there wasn't a similar final decision in that case. Russia has just ignored it. Of course, Russia is in a stronger position to ignore the International Court of Justice than Israel is. So this is a problem. Having said that, I may wonder whether it's the invasion of Ukraine by Russia. You can wonder whether the repercussions that have ensued from that have been, a lot of people would say they've also been bad for Russia. So it's not entirely true to say that no one else suffers from what the International Court does. But the International Court of Justice definitely deals unfairly with Israel, and the whole international community does, compared with the way it deals with other countries.
Yeah, for sure. Thank you, Seth. Can I turn to Larry Hochberg? He's a founder of ELNET and our chair emeritus. Larry, would you like to put your question?
First, a statement. What wonderful work you've done, really, Mr. Turner. It's extraordinary, and I think the 100 or so people listening to this are amazed by it. My real question is, what further would you recommend ELNET try to do regarding the decision, or just let it go?
Well, there's no appeal from the decision, but I think try and convince our friends and wavering friends, or people who are somewhat in the middle, try and convince them that this is, first of all, point out that this is a completely non-binding opinion of the International Court of Justice. It was requested by a minority of nations in the world, for what it's worth, and most of those were countries that didn't recognize the existence of Israel. So its authority is rather limited, but most of all, its authority is limited by the fact that it is based on the information that was provided to it. You know, as they say with computers, garbage in, garbage out. The value of the output is only as good as the value of the input. And if you proceed on the basis of completely inadequate and unreliable and incorrect information, what you get out of it is inadequate and unreliable. And I think try and persuade our friends that this is the case, and that they shouldn't treat it as a valid basis for their decision making. I hope, at least in some places, they may be receptive to that. I think, I mean, I don't know to what extent we hold sway with people in Israel. I personally think that Israel should have a more robust approach to international tribunals. I would query whether it was the best decision not to participate in this. I understand the reasons for it, of not wanting to give it any credibility, but even so, if you don't tell the facts and the correct analysis, it's more likely that the court will proceed on the basis of the wrong facts and will analyse the situation incorrectly. I think one really needs to grit one's teeth. But then, having done that, to be very forthright in terms of what one says, and not beat about the bush, to say, frankly, you know, this is untrue, that is untrue, that's not correct, this is what actually happened. And I think this applies also to the cases where Israel is participating, such as the genocide case brought by South Africa. I would like to see a very robust approach from now on in dealing with that case. And that's not to in any way criticize the Israel's legal team, but I think they will draw conclusions from this. I think they should have actually objected to Nawaf Salam, the president of the court, presiding over it. and actually, I think other countries should do that as well. I think it's unfortunate that the challenge didn't take place the moment he started presiding over cases involving Israel. But I don't think it is too late to do so. It does harm the credibility of the challenge a bit. But things have happened since then that can be raised as reasons why it's become even more necessary that he recuse himself. The way, for example, in which he gave Israel 25 hours over Shabbat to respond to a question by one of the judges that required a detailed factual response was when there was absolutely no need to do it in that way, was I think quite plainly of a racist nature. I'm sure he was aware of the impact that would have on Israel's ability to respond. That was in the genocide case.
Right.
So I think his involvement in the case, and possibly look at one or two of the other judges, and I think shame the court. Now, these challenges will be rejected by the court, but it enables us to say, well, even though it was pointed out that judges supported by Hezbollah, which is at war with Israel, he still chose to sit. And we think this shows complete inability to view the situation objectively and fairly. And this colours the whole opinion.
And if those points are made, we as NGOs can then amplify them and use them. But if they're not made, then that is a bit more difficult. Can I bring in Baroness Deach, who's a member of the House of Lords in the British Parliament? Ruth.
Yes, hello. It's just I'm very conscious, I think, of double standards. Britain in particular tends to pride itself on observing the rule of law. But there is an outstanding advisory judgment on the Chagos Islanders of many years ago. Britain evicted the Chagos Islanders. The ICJ, as far as I recall, told Britain that this was illegal, and they completely and absolutely ignored it. So anytime someone raises this, I'm going to say pot calling kettle black, because our own adherence to the ICJ is bad. But I'm sorry to say that even some of our own judges, albeit retired, have not shown the impartiality that they should, as Jonathan will recall.
Thank you. Yes, I think double standards in relation to the to Israel and the standards that Israel's held to, that no other democratic country is, are completely unacceptable. Can I call on Adam Goodvash? Adam, are you there? Can you ask your question? Adam?
Sorry, it's actually Janet, his wife, speaking.
Hi.
Sorry, I don't know what's happened with the camera. Apologies.
No
yeah, I mean, you've just touched on it to some extent, but whether some sort of conflict of interest claim or an application for accusal had been submitted against the presiding judge, just given how much evidence there appears to be about the extent of his interest against Israel. It just seems like in any other legal proceeding, if somebody is that invested against one of the parties, applications would be made for them not to be the presiding judge.
Yes, and the International Court is very resistant to these challenges, partly because it's composed of politicians, and they may be legally qualified politicians, but they do tend to be politicians. I think Israel may have felt it wasn't worth doing because in the previous advisory opinion case concerning Israel's security barrier in and around the West Bank back in 2004, they had objected to Jordan's former foreign minister being one of the judges in the case. Considering an issue about relating to the status of the West Bank, which Jordan claimed to be its territory, and had done so over many years, and who had again criticised Israel on many occasions very vehemently in international fora and elsewhere. So Israel objected to him being a member of the court, and that was also rejected. But I think it is worth making the objection. It's not going to make them any friendlier by not taking the objection.
But it's a fuller picture. I've been asked to ask you, Jonathan, where can we read Professor Ephraim Karshu's essay regarding life in Palestine under Israel control?
Well, if you look up Ephraim Karsh, and the title of the essay is "What Occupation?" If you look it up on the internet, you will find copies of it. It was originally published in Commentary magazine, and I think for a long while it used to be behind a paywall in Commentary, but I think it's now actually on open display on the internet in Commentary. But there are also copies of it elsewhere.
Okay, maybe they might try to get that in the chat, possibly. If not, we can make it available. Can I ask Josh Windsor of somewhere called Great Neck, New York? Sounds fascinating. Josh Windsor, would you like to put your question? I think the article, the paper you're talking about has just gone into the chat, Jonathan. So if anybody on the call wants to access that, it's there for them. Josh Windsor, put your question, please.
Good afternoon. I think actually my question, which was, would it have made any difference if Israel had participated, or were the dice so loaded against it that it wouldn't have made any difference at all? I think it came out in the discussion we just had. But if Jonathan wants to add anything, that would be great.
Yeah. Well, I think
also, Jonathan, can I just add to that? I know you've said these findings are advisory in nature. But what are the next steps that we should expect from the court or other UN bodies and organisations in the light of this opinion? How does it impact on some of the other cases that we know are likely to be raised?
Yeah. So dealing with the first point. It is quite possible that there would have been a very adverse result, even if Israel had participated. But if all the key facts are fully and vigorously presented, and if the arguments are fully and vigorously presented, and the court disregards them, I think it has more of an impact in undermining the adverse opinion that may be given. You can say, well, it was pointed out this, that, and the other, and the court just completely ignored that and said the contrary. So I think it has. And also I think one of the things about this you've got to consider, and this in a sense goes into your second question. Legal processes are a bit of a continuum. Although this particular case is now finished in the sense that as far as the International Court of Justice is concerned, in that the opinion has been given, it sets the stage for the next case and the next case after that, and so on. And I think it's our position in the international legal world is now so dire, so difficult, partly as a result of a view being taken that it's better not to turn up, which, as I say, I will question the desirability of that, or the political soundness of that approach. I think what it has the effect of making it easier for our opponents to build up this whole phalanx of points and assumed facts and assumed situations that make it a sort of complete miasma to try and get through, as you go on. And I think if we don't start now in really pushing back strongly against this creeping encirclement and undermining of our position, it will just get worse and worse. They'll say when they finished with the 67 borders, they'll start on the 1948 ones or 1949 ones and say that that's not Israel's territory either, and so on. I can see that coming up as the next target. What will happen regarding this case is it's likely to be it's an answer to the General Assembly. So it will be raised in the United Nations General Assembly, and there will be a vote on it in the United Nations General Assembly, saying Israel is appalling and hasn't complied with the opinion, and demanding that Israel do this, that, and the other, which will be disregarded by Israel, presumably, and demanding that the Security Council does things in relation to Israel. And then it will go to the Security Council probably, and we'll have to hope that the United States, under whichever president is in office at the time, we have to hope that he or she decides to veto what most of the other members of the Security Council will vote for, saying we're merely voting to give effect to the advice that or to put into practice the advice that we've been given by the International Court of Justice.
Can I ask you a final question? A little bit close to home for us. The previous UK government published a legal challenge to the ICJ concerning the separate genocide case. Has either the UK or any other European countries published similar challenges on this or the accusation of genocide? Does this ruling, will it play in to these other cases and also the ICC case around arrest warrants? Do you think these things amplify each other and magnify the situation?
Yeah, they do certainly amplify each other and have cumulative impacts on Israel's ability to defend itself and carry on its trade and other relations. As regards the ICJ genocide case, I'm not quite sure what the UK has done. There are several different cases now going on in the ICJ. So the South Africa's case against Israel, I don't recall the UK intervening, but I may have got that wrong. I apologise if I have. The UK has certainly, the previous government sought to intervene in relation to the ICC case, the criminal complaint against Netanyahu and Gallant, the allegations there that don't go as far as genocide. Karim Khan has not alleged genocide, but has alleged the principal basis on which he has said in his public statement, this is the prosecutor of the International Criminal Court, he has said that he is seeking arrest warrants against Netanyahu and Gallant, essentially on the basis that they adopted a policy of starvation of Gazans in order to achieve as a method of warfare. One point this arises in relation to this is the jurisdiction of the International Criminal Court, on which the UK and a number of countries have previously submitted observations, as well as quite a large number of NGOs, including UKLFI ourselves. And previously, the International Criminal Court had issued a majority ruling saying, for present purposes, at the present stage of investigation of the case, the investigation should proceed on the basis that the International Criminal Court has territorial jurisdiction in the territory of Palestine, which we regard as, that's the International Criminal Court regards as the West Bank and the Gaza Strip. But they did say that this could be reconsidered if there were applications for arrest warrants or for the requests for the attendance of witnesses. And that, of course, is the stage that has now been reached. So the UK government said, well, look, we've reached this new stage. And previously, when you dealt with the case, you didn't deal very fully with the Oslo Accords. Because the argument was being made that under the Oslo Accords, jurisdiction over Israelis was specifically excluded. And the theory adopted by the parties to the International Criminal Court when they signed up to the Rome Statute of the International Criminal Court, the international treaty that establishes it and regulates it, the concept that was adopted was that the member states could delegate their existing criminal jurisdiction to the court. And the argument goes that the Palestinian Authority, which came to be treated as a state of Palestine, did not have jurisdiction over Israelis because that was specifically excluded by the Oslo Accords. So that was the argument that the UK government wanted to, the previous UK government wanted to put up. The request for permission to make these observations has well, the International Criminal Court said you have permission to make observations, and the UK government is now considering, and of course it's now the new UK government, is considering what observations, if any, to make. And we don't know what they've decided on that. And so I can encourage people at ELNET to put in, express their views on this, that it would be undesirable for the court to undermine the Oslo Accords even further than the International Court of Justice has already done. And also the proceeding is deeply problematic because, frankly, sorry, I'm looking. I see you're looking at your watch. I'll be
no, go on. Finish.
But we've had a good look at the written statement of the prosecutor of the International Criminal Court. The actual applications for arrest warrants themselves have not been published, but he did make a statement saying these are the principal grounds on which I've applied, and they are entirely false. And every sentence of the explanation of why arrest warrants have been applied for against Netanyahu and Gallant is simply untrue. Now, I don't know what else he may have said in his applications, but to the extent that these are presented as being a summary of what he said, the applications must be based on false information. And this is certainly a point that we wish to make, and I can't say any more than that because anything that we may or may not have said to the International Criminal Court is confidential at this stage. But we certainly do express concern over this, and indeed I did write an article summarising those concerns within a very short word limit for Spectator magazine, so you can go back to that to see a brief summary of some of the points that can be made.
Well, Jonathan, thank you so much. It's been illuminating and clarified a lot of points in what is a complex set of court hearings and outcomes. So I'm now going to pass over to Sia, who is our West Coast Director of ELNET UK, who's going to close the meeting. But it's been really great having you on this Zoom, Jonathan. See ya, Kurdistani. It's over to you.
Thank you so much, Joan. I'll say ELNET US, but if there's an opening in ELNET UK, I will consider it as well.
If we're on it.
Thank you so much, Jonathan, for this very worthwhile briefing, extremely informative, and for all your work to strengthen the pro-Israel case from the legal international standpoint, and for your friendship to ELNET. And thank you so much, Joan, for doing a wonderful job moderating this session, and to those who asked really smart questions. Israel is fighting a 7-front war in Gaza, the West Bank, Lebanon, Syria, Iraq, Iran, and Yemen, as you all know from 2 days ago and for the last several months. And on top of this 7-front war, per our discussion today, Israel is fighting a war against delegitimization in international legal bodies and the United Nations. While the news cycle turns more rapidly, we at ELNET are focused on long-term relationships with Western democracies to shore up Israel's alliances. We don't have time to get into everything we've done since October 7, but as many of you know, we've had 31 delegations since October 7 from 25 European countries. That's nearly 300 members of parliament from national parliaments and the EU Parliament in Brussels, and other important leaders and journalists, along with a range of other activities and important accomplishments by our European directors, our Israel office, and others. I want to thank those who've made their annual contribution to ELNET so far, and I want to make an appeal to those who have not yet joined our movement to consider doing so today. And please spread the word about ELNET among your family, friends, work colleagues, and your synagogue and other community organizations. Thank you, everyone, and please stay tuned for our next Monday ELNET global briefing with an expert. The invitation will be going out in a couple of days. Have a wonderful week, and thank you so much.
Thank you. Bye, everybody.